Good morning, small business owners of California. My name is Claire Whitmer, and I'm the acting director of the California Office of the Small Business Advocate. And I am very excited to be able to substitute today for the normal host of this webinar series, Isaiah Green, our head of our regional economic engagement team. And he is on a very well-deserved vacation. So my job today is to introduce our partner and subject matter expert, Bianca Saad, General Counsel of Labor and Employment from the California Chamber of Commerce. And we have a jam-packed agenda today. I'm talking about California's policy leave regulations. So we will get to it as quickly as possible, but this is a very condensed, dense presentation. So if you are not able to stay to the end or you want to re-watch this webinar, you can find it on our website. We will put the link into the chat, calosba.ca.gov. You can click on our YouTube channel from the header or go to connect with CalOSBA, and you will find a list of this, you will find a recording of this webinar today and the entire series of webinars that we have done with California Chamber. So I'm going to pass over to Bianca because she's got lots of information to share today. But before we get started, I just want to say a personal note, Bianca, that I am myself a former small business owner in California. I ran a logistics business with my husband for 3 years. In peak season, we had 80 or 90 employees. We hired more than 300 people over the course of that 3-year period. And my role in the company, we did not have an HR manager. My role was to do HR compliance and hiring and onboarding policies. So I know very personally how much anxiety and fear these topics can generate for a small business owner who does not have access to a legal partner or a professional HR manager. Fear of doing the wrong thing for the employee, or of incurring unnecessary expenses, including fines, and worst case scenario, a lawsuit. So it is so important to California and to CalOSBA that we were able to partner with the Chamber on this series, and so grateful for your time and effort and expertise on this topic. And we're not allowed to endorse any dues-paying organization, but I'll just say that I was a member of the Chamber when I ran my business. So thank you for all that you have done with us and for CalOSBA and for the information that the Chamber provides to small business owners. So I'll let you get to it.
All right. Well, thank you, Director Whitmer. I'm so excited, as always, to be here to speak to all of you business owners. As Director Whitmer mentioned, yes, there is so much to keep track of in California. And when you are a small business and you don't have your own dedicated HR department, it can be a lot. So we are going to try to bring awareness, mainly because we don't have a lot of time. So that's my main goal. Now, before we jump into the very jam-packed agenda, just a few disclaimers. Again, for those of you who've been following along the series, this shouldn't be new by now. Just a friendly reminder, nothing in the presentation should be construed upon as legal advice, relied upon as such. I am an attorney, but I'm not your attorney. We're not permitted to give legal advice. If you do have a specific situation, that you need to get addressed, you should be consulting with a qualified attorney. Another reminder for those of you who are going back and reviewing this on the replay at a later date, that the contents of the presentation are current as of the date of the presentation. As we all know, in California, things move very rapidly. So, just keep that in mind when you're looking back. And then lastly, just that the presentation not be recorded, duplicated, or distributed, either in whole or in part, without written consent from CalChamber and CalOSBA. All right. So here's the fun stuff. This is our agenda. It's a lot, as you can see. We could do a full webinar on any one of these bullet points and then some, likely. So we're first going to touch on California's mandatory paid sick leave. Now, I am going to keep that piece short, only because we actually have our previous episode was a dedicated topic all around California's mandatory paid sick leave, because it is something that essentially all employers have to provide for their employees. So if you are curious about that, or you think you have remaining questions, definitely go back and check out that previous episode. Then we're really going to dig into some of the more heavier hitters, if you will. Pregnancy disability leave, that's a big one that employers, again, small coverage, we're talking 5 or more employees. Similarly, the California Family Rights Act leave. Now, I will note there is a corresponding federal leave, that's the FMLA, the Family and Medical Leave Act. Again, because we're focused on state leave laws today, we aren't touching on those. That is going to cover you if you have 50 or more employees. So I do want to just make folks aware if you happen to be in that larger employer size, but today we are just primarily focused on CFRA. Then we're going to talk about time off as a reasonable accommodation under the Fair Employment and Housing Act. What do we do if we're in a situation where there isn't, CFRA coverage or PDL, but somebody is unable to work due to a disability? That's going to put us into that category. And then just a quick highlight of all of the other state leave laws that we have to be aware of. Again, not getting into the details of it, but really it's important to just at least have that awareness to know that they're out there, so that you can then consider this your first step, and then you can go and educate yourself more around those state leave laws to make sure that you're providing your employees all of the protections and leave that to which they are entitled. And then we're going to wrap it up just with employee handbook reminders. We've kind of baked that into all of our webinars at the end, because handbooks are important, although not legally required, to have a comprehensive handbook, along with some key takeaways, just for, again, a quick snapshot of where we've been. So without further ado, let's get right into it. Again, California's mandatory paid sick leave. This is something that is going to apply to all employers, regardless of size. And it applies to any employee who's working in California for that same employer for 30 or more days in a year. As you can see, it's not much time, right, before they're going, before an employer needs to provide that. What it provides is 5 work days or 40 hours of paid sick leave per year, whichever is greater. So that may differ depending on the standard shift length that an employee has. So if you have an employee that is working, 10 hours every day for 5 days. So, 50-hour weeks, they're still going to be entitled to 5 work days of PSL. So there's 2 ways that you can provide PSL, either an accrual method, meaning they're going to work they're going to earn that paid sick leave as they work. And the standard for that is 1 hour for every 30 hours they work, they will accrue it. Or you can provide it all in one big lump at the beginning of the year. So those are the 2 main options that you have. And again, it can be different depending on classification. Some people have, their part-time employees are provided maybe accrual, full-time lump sum, vice versa, whatever is going to work best for your organization. And there are, again, if you're doing accrual method, there are certain caps and things. Again, we go into much greater detail in the previous episode around that. Just some reminders of what can you use paid sick leave for. It is very broad. It covers preventative care, the diagnosis, care, or treatment of an existing health condition for the employee or for that employee's family member or a designated person. Family member is very broad. We're going to see that group of family members that is also included when we'll talk about California Family Rights Act. And again, you have those additional details in our sick leave episode. Now, sick leave can also come into play if somebody is an employee or their family member is a victim of a qualifying act of violence. So it can come into play for those circumstances. And then also for our agricultural workers, if it needs to be used to avoid working outside in smoke, heat, or flooding conditions that are created by a state or local emergency. So PSL, like with the other protected leaves that we're talking about today, it's protected time off. So what does that mean? So first and foremost, for paid sick leave, it's up to the employee when they are going to use it. We can't dictate. So if an employee says, I need time off to go to a doctor's appointment, we can't unilaterally apply that. We need to ask them and clarify, do you intend to use your paid sick leave for this? Similarly, if they're calling us because they're sick, we can't just assume that they want to use their paid sick leave or require them to use it. We need to clarify that that is their intention. And if they are using their paid sick leave, then what that means is we can't deny the use of it. We cannot require them to find a replacement worker or condition it. And we certainly cannot take any adverse action against them for using that time. Again, the idea is it's protected. So we can't do things like discipline, suspend, or terminate somebody for using their protected paid sick leave. So if you have an attendance policy, for example, where you're providing points or occurrences for absences that kind of go against their overall performance, you would not be applying those in situations where they're using paid sick leave or some of the other leaves that we're going to be talking about. There are poster and notice requirements with paid sick leave, as we'll also see as the theme throughout for the other leaves that we're going to talk about. So you need to have that poster up in your workplace. Their information around your policy and how you're providing it should also be on that wage and employment notice that goes to your non-exempt employees at the time of hire. And we need to make sure that our pay stubs also have information about paid sick leave. If it's not on the wage statement, it needs to come in some separate writing that is coming with the payment of wages. All right, so again, just really quick reminder, because that's one of the big important ones. Again, all employers need to provide it. Doesn't matter how small you are, we need to make sure we have that paid sick leave provided. So now let's talk about pregnancy disability leave. Pregnancy disability leave is also going to cover our smaller employers. So anybody who has 5 or more employees will need to provide this to an employee who has the need. And this is also a bit unique in that employees are eligible upon hire. So we don't have to wait for them to be employed with us for any certain amount of time before they are eligible to take this leave. You could have an employee who comes to work for you and on day 1 notifies you that they're pregnant and they have a need for this leave. That is okay. So what is it in terms of how much time is provided? So it's up to, and I always like to put the emphasis on the up to part. It's 4 months, and that also breaks down to 17 1/3 weeks of unpaid protected time off when that employee is disabled by pregnancy. Now, the reason it's not an automatic guarantee of that length of time. It's all going to be based by the healthcare provider and whether or not they are indeed disabled by pregnancy. Somebody could use only some of that time. Somebody could use all of it and then still require to be out. So it's really going to be on a case-by-case basis. Under the law, there's also a component to reasonably accommodate and or transfer employees who are what is referred to as affected by pregnancy. And we'll talk about the distinction between these two terms in a moment. And of course, there are also anti-harassment and anti-discrimination protections under the law. So what does it mean to be disabled by pregnancy? They're going to be considered disabled by pregnancy if they're unable because of their pregnancy to perform one or more essential functions of the job. That's going to be determined by your job description. Hopefully you have essential functions for that role. Or if they're unable to perform any function without undue risk to themselves, other people, or the successful completion of their pregnancy, meaning they couldn't complete those things without putting themselves or others at risk. So it covers a wide variety of conditions. Some of the larger ones that we see, but again, this isn't exhaustive, is severe morning sickness, prenatal and postnatal care, recovery from childbirth. So somebody could be disabled by pregnancy both before the child is born and then after, right? Because even once the child is born, there's still that recovery period. And again, this is all determined by the healthcare provider. So we do have a medical certification component to this leave, that we would expect our employees to provide, again, to substantiate the need for the leave. Now, we talked about the fact that there's also a reasonable accommodation component if an employee is affected by pregnancy, and the accommodation, again, it's medically advisable, right? So we're getting that medical certification from the healthcare provider. In that situation, we need to engage in the interactive process with the employee regarding what is the accommodation that's needed. Again, this is going to be a case-by-case basis. It can be things like modifying work duties or work schedules, providing or modifying furniture or equipment, or it could even be a transfer to a less strenuous or a hazardous job during the pregnancy. So, just to be aware, PDL, it does cover more than just the time off for leave. Now, a quick note for those of you who may have 15 or more employees, we also have the Federal Pregnant Workers Fairness Act, or the PWFA. That law is also an important one to be aware of. Again, due to time, we're not covering it in detail on the slides, but just want to flag it for you because there are some additional predictable assessments is what they're referred to, where there are certain things we're doing essentially that don't require any medical documentation from the EEOC's perspective. So things like allowing the employee to carry water, allowing them to sit when they normally stand, or to stand when they normally sit, more frequent restroom breaks, things of that nature. So there are some places where the federal law does deviate from California law, and it's important to be aware of both of those requirements when you have a pregnant employee. All right, so what are our obligations around health benefits for our pregnant employees? We do, as employers, need to continue those health benefits for the duration of the PDL, and that's at the same level and under the same conditions as if that employee was still working. So nothing is changing around their health benefits. Now, we can still require the employee to pay their share of the premium, but the important piece to be aware of here is that we can't stop the coverage even if the employee doesn't make those premiums during the leave. So we'll see, like with some other leaves, we do have a mechanism by which we can actually cancel due to non-payment. We don't have this with pregnancy disability leave. So the best practice is going to be for you to make those payment arrangements with your employee before the leave begins. Now, this is another good place for me to flag that, as we talked about, pregnancy disability leave is an unpaid leave, right? So they're not collecting their wages from you, the employer, during this time. What they could do, though, is they can collect a wage replacement benefits through the EDD, and they can, and SDI would be the applicable wage replacement benefit while they're out on PDL. And so they do have a mechanism by which they can get wage replacement. And then they can also coordinate if they have, let's say, things like vacation or sick leave saved up in their banks of time, they can use those. So let's say if somebody's drawing on their vacation benefits while they're out on PDL, in order to get themselves up to 100%, adding their SDI plus the additional needed to get them up to their full wages, we could make those health premium deductions from their collection of the vacation during PDL. But we need to, again, know what our employee plans to do. If they're not doing that, maybe they don't have it or they don't want to, then it could simply be they plan to send us a check. Okay, so but whatever it is, you want to make sure you have a plan in place. And then it's also important to note that the PDL health benefit continuation, it is separate from the obligation that we'll talk about that falls under CFRA leave. So even if they're then no longer disabled by pregnancy, they go out on child bonding leave under CFRA, there's a separate obligation to maintain benefits under that law. So it's not just they're only going to have health benefits maintained during PDL necessarily. All right, and what happens when an employee is ready to return to work after PDL? They do have, again, the idea with all of these protected leaves, right, is that an employee who goes out on leave is going to be entitled to pretty much come back to their job. The law refers to it as the same or the virtually identical position. Now, it is true, though, they don't have greater rights than if they had remained employed. So what that means is, for example, let's say the employee would have lost their job if they hadn't been on leave. So let's say during the time that that employee was out on PDL, company goes through a reduction in force, has to lay off individuals. They have their objective criteria for how they're making those decisions. This employee who was on PDL was included in that layoff. We don't have to then reinstate them, because had they been here, they would have been laid off anyway, right? So that is the case. Some, I guess, relief for employers who may have concerns about that. But I also want to caution folks that you have to be careful if you are doing something like going through a layoff. You always have to exercise caution around your employees who may be on leaves, because what you don't want to do is create a perception that you're simply targeting those individuals who are on a leave for the layoff because of the fact that they're on a leave, right? So, but, assuming everything is, above board there, again, they're not entitled in that limited situation. So what do we do, though, if an employee, let's say they've exhausted all of their 17 1/3 weeks of leave, let's say maybe due to a high-risk pregnancy, they started taking PDL very early into the pregnancy, and maybe they're still pregnant, or to the point where they exhausted it right up to the time they had the baby. There's recovery time after, but they don't have anything more, and they're still disabled by pregnancy. So in that situation, then we may need to provide additional leave as a reasonable accommodation under the Fair Employment and Housing Act. And we'll be talking more about that scenario. And that scenario can come up, this is one way it can come up, and it can come up in some other ways that we'll talk about as well. So, continuing the theme again with poster and notice requirements, PDL is no different. The notice required under this law is your rights and obligations as a pregnant employee. Now, this one is unique in that it actually does allow electronic posting. Most notices actually don't have a specific call out for electronic posting. But the caveat here is it's only if it would be in a conspicuous place or places where your employees would tend to view the notice in the workplace. So if your employees don't tend to view notices electronically, then that's probably not going to be the best way, right? So we still can have it physically displayed up in the workplace. Now, if we do have our workforce where at least 10% speak another language, we do need to have that notice translated into that language. We need to provide the PDL notice to employees when they disclose their pregnancy, or if they're requesting a leave, accommodation, or transfer, pretty much anything related to their pregnancy that they're needing and they're coming to you, you want to make sure you're providing that notice to them. And we do have timelines in terms of responding to an employee's request. So it should be as soon as practicable, but no later than 10 calendar days. All right, so that is, again, kind of the high level of pregnancy disability leave. Again, the things that I just want to highlight that we covered was the fact that you only need 5 or more employees to be covered under this law, and there is no minimum service that an employee has to give to you in order to be eligible, right? They can come to you on day one, have a need for either accommodation or a need for the leave. They are going to be entitled to it if they are disabled by pregnancy or affected by pregnancy. So now let's talk about the California Family Rights Act leave, or CFRA. And as I mentioned, we're not covering, oftentimes we cover this law alongside the federal FMLA, which covers those with 50 or more employees. So again, just keep that in the back of your mind if you are of that size. But we're going to focus on those who are, really covered by CFRA, and that means they're directly employing 5 or more employees on a regular basis. So regular basis refers to the nature of the business that is recurring rather than constant. So in other words, you don't have to have 5 or more employees every day of the year to necessarily be covered. It's going to depend on what is the nature of your business and what is a regular basis according to that. So what the leave provides is eligible employees with unpaid leave for certain qualifying reasons. Now, employees do need to meet certain eligibility requirements. So let's take a look at what that is. So we have that the worker needs to have worked for you for at least 1,250 hours in the 12 months preceding the start of the leave. And they need to have worked for the employer for at least 12 months total. So the 12 months doesn't have to be consecutive, but breaks in service cannot exceed 7 years, the exception being if it's due to military service. So let's say you have an employee, they worked for you for, a few years, and then they took a break and they're rehired. We can actually go back in the previous 7 years to meet that 12-month total requirement, but they still would have to meet that first bullet, which is, so we need to look at, did they work for us for at least 1,250 hours in the 12 months preceding the start of the leave? So they're going to need both. And, as I mentioned, I might call out some FMLA related things again, just in case some of you are out there. FMLA has a third requirement for this that has to do with the work site where the employee works. So it is possible that you could have an employee, you might be an FMLA covered employer, but somebody still might not be eligible for FMLA. So just something to keep in mind. And if CFRA and FMLA both apply, then the banks of time are drained together at the same time. But again, not to confuse or overwhelm, because I know it's a lot. So we are going to just jump back and focus on the CFRA. So just those two bullets for CFRA employee eligibility. So now let's talk about, well, how much time can somebody take under CFRA leave? So if an employee is eligible, they're going to be able to take 12 weeks of unpaid leave in a 12-month period. Now that 12-month period is going to be determined by your policy. So it's up to the employer. So we have some options there. It can be a calendar year. It can be some other fixed year, like if you operate according to a fiscal year. Or it could be a 12-month period measured forward. So what that would look like is from the time that the employee goes out on a leave, we're looking at what are the 12 months going ahead, and that's going to determine the 12-month period. Or we look at it rolling backward. So with rolling backward, what we do is if an employee needs leave, let's say as of, March 3rd, we look at that and we look back going, March 2nd and the prior year, and we ask ourselves, did that employee use any weeks of CFRA leave during that prior year? Let's say they used 3 weeks, and that means as of March 3rd, they have 9 weeks available. So that's how that calculation method works. Again, up to you, does need to be defined in a policy. This is where having a policy is really going to be important. If you don't have it defined, then whichever is going to be most beneficial to the employee is what would be applied. So when we're talking about the 12 weeks of CFRA leave, it can be continuous basis, meaning one large 12 weeks of leave in one big chunk of time. Or what is often the case is it can be intermittently. So meaning it's smaller increments of time, right? Just like in that example where we talked about, if it was 3 weeks, or it can even be smaller to where we're talking about, half days. Somebody needs it for certain treatment appointments, things like that. So it can be used intermittently or continuously, but either way, we have to track and make sure that it's up to that 12 weeks within that 12-month period. So now let's talk about then what are the qualifying reasons for leave? Why would somebody be able to take this leave? So the employee's own serious health condition, and that would be substantiated by a medical certification. Serious health condition does have a specific definition. It's not your average cold or flu, right? It could be something where you have your inpatient treatment, or you're overseeing, you have you're undergoing a treatment that requires medical supervision. Again, it's a very specific definition, and that's something that the healthcare provider would be confirming that, that employee meets the definitions of a serious health condition without, of course, getting into the specifics of diagnoses or anything like that. Then another reason that somebody could use it is to actually care for a family member for that family member's serious health condition. Now, that would also be substantiated by a medical certification. So, and we'll talk about who the qualifying family members are, but it's that family member's medical provider that would be confirming that that family member has a serious health condition that requires care and that the employee is indeed caring for that family member. So that also has the medical cert component to it. The third reason somebody could use this leave is to bond with their child. So whether it's the birth of their child or adoption or fostering of a child, all of those will be triggering events for eligibility to use child bonding leave. And then we also have qualifying military exigency, which is related to short-term deployment for certain family members. And so that can be things like needing to arrange childcare due to short-term deployment. There are a lot of situations for those. There would be documentation for this. It would be driven by, again, depending on what the circumstances are and the reason for the need for the leave. With child bonding, there is no specific requirement. Oftentimes we get the question about, well, can we require a birth certificate? And you could choose to have that as your policy. However, there's nothing in the law that prevents it, but there's also nothing that requires it on the employee's end, I should say. But oftentimes what happens is we see that policy directed toward male employees or non-birthing employees who are the parent of a child, where they're not making that same requirement of their employee who was very visibly pregnant and had the child, right? So if you are going to have such a requirement, you need to make sure you're consistent for all of your employees, regardless of who's birthing the child or not. Okay, so when we talk about caring for a family member, qualifying family member, serious health condition, here is the list of qualifying family members under CFRA. And you can see it's very broad. It largely aligns with the qualifying family members that I mentioned under paid sick leave, with the exception that designated person has a slightly different definition for paid sick leave purposes. But what we're talking about here is a child of any age, a parent or parent-in-law, a spouse, registered domestic partner, grandparent, grandchild, sibling, or a designated person who for CFRA purposes is any individual related by blood or whose association with the employee is the equivalent of a family relationship. So for a designated person, though, you could limit it to a single person within, per 12-month period. So again, this is where having a policy is going to be wonderful, because you can make that very clear in your policy so that your employees know what to expect about that. All right, so health benefits, because we talked about health benefit continuation under PDL. We have a separate entitlement to health benefit continuation under CFRA leave, again, at the same level and under the same conditions as if the employee had not taken the leave. Like with PDL, we can require that employee to pay their share of the premium, and we should, be making those payment arrangements before the leave begins for, again, how they plan to do it. Now, unlike PDL, though, we do have a mechanism by which we can stop the benefits if an employee is not paying their share of the premium. But with some conditions, we need to meet a couple of conditions. So first, the employee's premium needs to be more than 30 days late. And then second, we need to give a notice of non-payment at least 15 days before the coverage will end. So before we can stop coverage, we need to make sure that those two things are true. If somebody makes their payment right at 30 days, right, then they're square, and we're not going to give that notice of non-payment. And even if they do go past 30 days, but we haven't given that notice of non-payment, we have to make sure, we do give that notice and wait at least 15 days before ending their coverage. Now, even if you end up meeting those requirements, you end up canceling benefits. Once that employee returns, they're going to be entitled to have their benefits reinstated immediately. upon return to work. So return rights, similar to what we saw with pregnancy disability leave, the employee must return to the same or virtually identical position. You can require a medical release to return, but only if the employee was advised when the leave began that you were going to make that requirement. And secondly, you do need to have a uniform policy that's applied to all of your employees who are returning from a leave after illness, injury, or disability. So if you have that uniform policy for all of your medical leaves that a release needs to be provided, that's fine. And we also need to make sure, though, that we're notifying that employee when the leave begins, that we're expecting that upon their return. Another protection that comes with CFRA leave is that it is not going to be considered a break in service for purposes of things like layoff, recall, promotion, job assignment, or any seniority related benefits. If we have any changes to benefit plans that are going on during the leave, we need to make sure that we're offering that to our employees, even though they are on a leave. So let's say we're going through open enrollment. We have employees that are on leave during open enrollment. We need to make sure we're getting them that information. They still have the ability to make their selections, even though they're on leave. All right, and of course, there are poster and notice requirements for CFRA as well. Again, needs to be posted up in the workplace in a conspicuous place where applicants and employees tend to congregate. You have there the official title of the notice. Like with PDL, we also have the 10% or more workforce speaking another language rule. So if anything other than English, we need to have those notices posted in that other language. Again, because we're limited on time, we didn't talk about in detail the fact that we also have to designate the leave once we have all of the information. So for example, if it's for the employee's serious health condition, we get a medical certification back. We know they're eligible, right? There's some documentation and that we need to provide to officially designate the leave as such so that the employee knows that this leave is indeed falling under CFRA. All right, so now we're going to talk about a little slightly squishier subject. What's nice about PDL and CFRA in particular is that, you know, we have very specific rules in terms of who's eligible and how much time is provided. So that makes things easy for us to know, you know, what we need to do. Well, then the question becomes, okay, well, let's say we have an employee who is not yet eligible, let's say, for CFRA leave, or they have exhausted their CFRA leave, but they are disabled and they are unable to work. And so what do we do in those situations? So first, just some foundational information is that, you know, we have California's Fair Employment and Housing Act. You know, this is sort of our state version of the federal you know, Americans with Disabilities Act, or ADA, that again covers 15 or more, those with 15 or more employees. Not our focus today. California is more protective in terms of coverage and how we define disability. But the Fair Employment and Housing Act prohibits employers from discriminating against applicants and employees because of their disability or perceived disability. So under California law, this is defined as a physical or mental impairment that limits one or more major life activities. And it's under this umbrella of the law, too, that employers have an obligation to engage in what is referred to as a timely, good faith interactive process and reasonably accommodate the known disability of an applicant or an employee, with the exception being if providing that accommodation would impose what is referred to as undue hardship. Undue hardship really is a legal term of art, and it is something that requires legal analysis. So if you're dealing with any form of an accommodation request, whether it's time off or something else, and you feel like it's unreasonable, you know, and you're wanting to deny it, that's really where you should be working with legal counsel, because undue hardship is a high standard to meet. It's not simply it's an inconvenience or it's going to cost you more money, right? Just as an example. So You definitely want to be working with the guidance of legal counsel before you're making any official determination. But let's talk about reasonable accommodation specifically in terms of what that is. So it's basically any sort of modification or adjustment that we're making to the job or the work environment that is going to allow that individual with a disability to enjoy an equal opportunity. So again, whether an accommodation is reasonable, it's always going to depend on the specific circumstances. It's always going to be a fact-specific inquiry. It's going to come down to things like, what is the role of the employee? What is the requested accommodation? What is the size of the organization, the financial strength of that organization? How does this accommodation potentially impact the overall business? I mean, there's a lot that goes into it again, which is why you should be making these determinations with legal counsel if you can. And one thing to note, though, is that we know is that an employer is not going to be required to eliminate the essential functions of a position as an accommodation. So something we talked about much earlier in the series around hiring and job descriptions is the fact that we want to have these essential functions clearly laid out in those job descriptions, because that's really like the heart and soul, if you will, of the position, right? It's a driving position, a delivery, where somebody's a delivery driver, right? They need to be able to operate a vehicle. They need to be able to drive that vehicle, again, depending on that role, right? So if that is an essential function and you have somebody who cannot perform that essential function, we're now outside of a reasonable accommodation. But that's where I like to flag that, because I think oftentimes the job description and the accuracy and currentness of those job descriptions can get overlooked. You should be reviewing those at least on an annual basis. Okay, so once we have a reasonable accommodation request, we have a duty to engage in that timely, good faith interactive process to explore the potential accommodations. So whether it's because that employee is requesting the accommodation from us, or maybe we become aware of the need. And a clear example of the second bullet is, I have an employee who's out on CFRA leave. I know based on the documentation they provided that they are going to still be unable to work for at least a month, but maybe they only have 2 weeks left of CFRA leave available to them. So we know that they don't have that, right? So now we know that we're in this territory. So with going through the interactive process, the goal is always to determine what are the restrictions that exist, what are the accommodations that are going to enable that individual to perform the essential functions of the position. Now, again, if they're disabled and unable to work, then leave as an accommodation, right? They're not necessarily performing the essential functions of that position, but the idea is that leave is going to facilitate their healing such that they can return to work and get back to performing the essential functions of their position. So like with the other leaves that we talked about, pregnancy, disability, CFRA, even if it's a leave under Fair Employment and Housing Act, we do have the ability to get that medical certification completed by the healthcare provider, right? We don't have to simply take an employee's word for it and not require anything. So documentation to show that you're going through this process, communication between you and the employee, it's really a back and forth a lot of times is going to be important, because that's going to help you to establish that you did engage in this interactive process in the event that it's ever challenged. So, like I mentioned, a leave of absence can in and of itself be a reasonable accommodation, so long as, of course, that leave doesn't create an undue hardship. Now, again, I caution everybody around that, because don't just assume because it's inconvenient that means it's an undue hardship, right? So this is a tricky area because there isn't any set amount of leave, right? That's sort of why it's a reasonable accommodation, and reasonable is one of those words that we see in the law a lot that can mean different things, again, depending on the circumstances. So it's always going to depend on the particular situation. Now, what we do know is that employers don't have to provide an indefinite leave, but of course, that's not really super helpful when practically speaking. We know it doesn't have to be forever, in other words, but there's a big gap there. So it's really going to come down to the circumstances. But we do want to make sure, of course, that we're engaging in the interactive process when we know that the employee may need that leave. So again, it could come up if somebody's not yet eligible for CFRA because they haven't worked for us long enough, or somebody's exhausted their PDL, they're still disabled by pregnancy, or if they've exhausted their CFRA and they're still unable to return to work. Like with the other leaves, it is unpaid. So, and because we don't have the specific set of rules like we saw with PDL and CFRA around health benefits, it's really going to come down to your company policy. So if you don't have a policy around that, you might want to think about, again, and this is where your handbook's going to be great to communicate that. So you won't have the obligation that is specifically outlined in PDL and CFRA to maintain those benefits, but it's really going to come down to, you know, working with your carrier and knowing what your policy is there. Okay, so we've got other state leave laws. There's a lot here on this slide. I'm just going to call out some of them. And again, we don't have time to go into all of the details. I mean, my team regularly has 2 half-day events just dedicated to all of the state leave laws, including CFRA and FMLA. There's just a lot to be aware of. But things like time off to vote, anytime there's a statewide election, if you have an employee who is called to serve on a jury or subpoenaed to be a witness, they're entitled to leave. Those are protected leaves. Bereavement leave is one of our newer leaves, again, for certain family members, and that's covered. Also, reproductive loss leave is one. So if we have employees who have lost a pregnancy or had an unsuccessful IUI, different things there, miscarriage, that is covered under reproductive loss leave. There are things that cover school activities, military, all sorts of military leave. While not a state leave, I did leave on there, the USERRA, that's the federal protections for, employees that we might have that serve. So there is a lot to be aware of. And again, unfortunately, we don't have the time to dig into all of these, but I think at a minimum, it's important for you to just to know how much is out there so that you can then educate yourself and make sure that you're providing the time that is permitted for your employees. All right, so just some takeaways and handbook reminders. I'm not going to read this slide word for word. We've touched on employee handbooks throughout the series and why they are important. Think of it as just a communication tool, right? It's clear guidelines, expectations. And when it comes to leaves in particular, that's a way that you can get the information out that you need to your employees. As far as what your policies are, who do they need to go to? Is it an HR representative if you're smaller and you don't have somebody, who's wearing that hat, and how do they need to go about, talking to somebody about those things? So yeah, I mean, again, we have more information from previous episodes around employee handbooks if you're not sold on the idea of having one. Again, not a legal requirement. But we do have requirements for certain policies, even if you don't have a standalone handbook. Now, paid sick leave, we do have, we have notice requirements for paid sick leave. We also have that notice to non-exempt employees that gets provided at hire has to contain certain information, but it's definitely going to be recommended that you also have a paid sick leave policy in your handbook, right? So that you can provide things like how much paid sick leave is provided. Are you providing it through a lump sum or an accrual? What are the qualifying uses? Are you imposing a 90-day waiting period? Some employers choose not to. All of the information around paid sick leave. For PDL, if you do publish an employee handbook that describes transfers, reasonable accommodation, or temporary disability leaves, then you do indeed have a requirement to also include information on PDL. Now, again, if you don't have a handbook, at a minimum, employers need to be giving their employees a copy of the PDL notice at least annually. For CFRA, if you have an employee handbook that describes other types of leave, so again, things like pregnancy, disability leave, or anything else, then you do need to also include a description of family and medical leave. So if you don't have a handbook, then those notices that we talked about, again, distributing those annually and to your new hires. But your CFRA policy is also where you would be able to refer to the fact that, you know, there may be leave as an accommodation. You could direct them to a separate policy there. You know, what happens if they, you know, if they exhaust or if they're not yet qualified. That would also be where you specify how are you calculating the 12-month period, things of that nature. And then, of course, for additional leaves, right, for all of the various leaves that are available, really, you could have a standalone policy for all of those leaves and even cross-reference to other policies, like I just mentioned, where, you know, it makes sense. So this is one of those areas where employers have a lot of obligations, and if you make sure you're communicating to your employees that they're receiving, you know, that they're what they're entitled to and when, that's really going to put you on solid ground. In addition, of course, to providing all of the various required notices, having those posted up in the workplace. All right, so I know we're running short on time, so just really big picture here. If you didn't get anything else out of this, the first thing I want you to know is that when it comes to leaves in California, awareness is key. You can't provide your employees the necessary leave if you aren't aware of them, right? So that was a big goal of mine today, is just to make you aware of all of the various things that are out there. Another thing, make sure your supervisors and managers are aware of those protected leaves as well, because, you know, they need to know if they're tracking their employees' absences, they need to know that certain absences are protected, right? So that they're not then disciplining their employees for using things like paid sick leave. Or they need to know when to be able to escalate something to HR. If an employee comes and says, well, I think I'm going to need a surgery, you know, that should be alarm bells going off. Okay, potential CFRA leave. We need to have whoever's in charge of that to get them the necessary notices and paperwork to get the ball rolling around that. And then, of course, we talked about handbooks. It is a best practice to have one, but even if you don't, you need to make sure that you're still providing policies that are required under the law. And we didn't even touch upon all of them. For example, all employers need to have a harassment prevention policy about preventing harassment, discrimination, retaliation in the workplace. And all employers also have to provide a lactation accommodation policy. So even if you're not providing that comprehensive handbook, you still need to have certain policies that you will be inevitably required to provide to your employees. All right, well, I have said a lot and not a lot of time, so I imagine we have some questions that I'm happy to take.
Wow, Bianca, I just want to say that I surely wish I had had access to this webinar series when I was a small business employer in the state of California. So thank you so much. We did have some questions come in, and I'm just going to read them to you in the order in which we received them. But before we get started, I just want you to know that Kathy P says, fantastic job to you, Bianca. So thank you for that. And first question, Christine H says, with PDL, it's my understanding an employer can require an employee use sick time, but may choose not to. I have a few questions regarding this, so I think I'll just let you respond one by one. First question, does the mandatory paid sick leave affect this?
Yes, that is, and correct me if I'm wrong, and feel free to drop it in the chat if I'm misunderstanding your question, but I think what you're referring to with that required usage of paid sick time is when we have these protected leaves, there are different rules about whether employers can require the use of available accrued time that an employee might have, whether it's sick leave, whether it's vacation or PTO, things of that nature. So when it comes to an employee who's on pregnancy disability leave, The law does allow employers to require the use of paid sick leave during any unpaid portion, meaning they're not collecting benefits through EDD. However, we have two conflicting principles there. So we have, on the one hand, yes, you can require sick leave, but on the other hand, if we're talking about California's mandatory paid sick leave, that is always going to be at the employee's discretion. So it's not that you could never have the requirement. It's going to come down to, for example, do you have a separate standalone sort of corporate sick leave policy that is completely separate from California's mandatory paid sick leave? Maybe you want to provide more paid sick leave than what's required, but you have like a Healthy Workplace, Healthy Families Act. That's the name of the act of California mandatory paid sick leave. You have that bank, right? And then maybe you have your company's bank of sick leave. You would be able to dictate the use of sick leave for your companies, but not under California's, if that makes sense. If that's not your question, feel free to drop in a variation and we'll get it sorted out.
So Christina's responding in the chat. So I think that you did understand that first question,
Okay.
and that made sense to her. Her second question, is that limited to the first 3 days of leave? I think you just touched on that, but to clarify again.
Yes, so any sick leave that is California's mandatory paid sick leave, we cannot require as the employer. It's always going to be up to the employee if they're wanting to, like, say, supplement their leave with that sick leave during the time.
Mm-hmm. And Christine's last question, what's the benefit of an employer requiring this?
Of requiring the use of sick leave?
Mm-hmm.
Yeah, so I think employers are always, interested in, it's a way to, well, that's a good question, because here's the thing, sick leave doesn't get paid out when, and I'm getting a little out of scope here, but it's relevant to the question. So when an employee is terminated, we don't have an obligation to pay out the sick leave. Versus vacation, right? That's treated by the labor commissioner as wages. We have to pay that out to them at wages wages when they're terminated. So a lot of times employers are more interested in what are the situations where we can require our employees to use their vacation when they're out on a leave, because then that's going to kind of get that down, right, in terms of what is the liability in the books if they're to later separate. I think I don't want to speak for everybody, but it's my understanding that's kind of the mindset that some people have. For sick leave, honestly, I think you don't have to require the usage. I think leaving it up to the employee a lot of times is perfectly fine. Whatever you're doing, though, you want to be consistent, and is just being consistent. And the reality is, a lot of times employees are going to want to supplement with the paid time that they have available anyway.
So yes, the accrued vacation time, if you have a lot of employees, as I did, 80 or 90 during peak season, the accrued vacation time is considered a liability. So it is something that has to be monitored for sure. So from Denise R. You referred to an acronym that started with PW, and she wasn't sure what the rest of the acronym was. She didn't catch it.
Oh, yes. So PWFA, that's the Federal Pregnant Workers Fairness Act. And that covers employers that have 15 or more employees. And again, we didn't get into the weeds on it, but I did want to flag it as we were talking about PDL, because employers who are covered by both do need to be aware, because there are some additional protections that PWFA provides that are not laid out under PDL. And we always want to make sure we're complying with both state and federal law.
All right, thank you. So next question from Maria B. Could CFRA start right after the employee exhausts their PDL?
It could. The only thing I would tweak to, just for clarity, is it's not a question of is the PDL exhausted. It's a question of, is that employee no longer disabled by pregnancy? So again, somebody may not exhaust all of their PDL. They're not automatically entitled to the full 17 and 1/3 weeks. So you really have, it's really a question of when that employee is no longer disabled by pregnancy. Let's take a straightforward, no complication, healthy healing scenario of an employee who gave birth to their child. Let's say they recover for, I don't know, 6 weeks exactly. At the 6-week mark, doctor puts them, clears them to return to work. They're no longer disabled by pregnancy. Maybe they know that date coming out to it. They could then decide, I'm going to roll right into my child bonding time as of the date that I'm no longer disabled by pregnancy. And a lot of times we do see that, but sometimes employees will come back to work for a time. They have within a year of the baby's, if it's a birth, of the birth of the child, to use the 12 weeks.
All right, thank you. And I think this is the last question from attendees. Susie M asks, when is the next LOA 2-day training?
Oh, great question. Yes, so we did actually just had our final one for this year. I think it will be stay in touch with us, but in March, and we'll be having a calendar at some point that has all of our upcoming dates, but it will be early in 2026. Where, yeah, we do a much deeper dive than what we were able to do in the time here.
All right, thank you. So I'm going to squeeze in one more question that I had from my experience as an employer. And for pregnancy disability leave, if a full-time employee just had a baby and now wants to return, but wants to return only part-time, do you have to allow that person a part-time schedule? Are you required to do that?
That's a great question. We see that one a lot. So what the employee returning from PDL is entitled to is their virtually identical position. So what that means is if our employee was full-time before they went out on leave, they're entitled to come back to their full-time position upon their return. So we're not required, but so if they're coming to us and they just out of, wanting to be at home more with their child, they don't want to work full-time anymore, they're not entitled to that. We could certainly allow it if we want, but we have to understand that if we're doing that for that one employee, we're now setting a precedent within our organization that we would then need to do it for others to not be concerned with any sort of unfair treatment claims, right? So it's not an entitlement that they have. Now, the exception to that is if an employee for a medical reason as an accommodation needs a schedule change to work part-time, then we're in the land of we need to engage in the interactive process, and that may be something that we need to provide. But if it's out of sheer preference, then no.
All right, thank you for that good clarification, and thank you for mentioning the idea of precedent as well, is that none of these are one-off decisions. So once you make a decision for one employee, it is effectively becoming your policy, and that's something really to watch out for as well, that you want to do something kind or right by that one employee, but there are bigger implications for your business. So Bianca, thank you so much for your time today and all the information that you have shared. And thank you for your partnership with through the California Chamber with CalOSBA. For those who maybe want to rewatch this webinar or see some of the episodes that they have missed, I believe that we are on the 8th out of 11 planned webinars for this series. Is that right, Bianca?
I believe so. Yes.
I believe so.
Time flies.
Time flies. We have done a lot of webinars on various employment law topics. So you can find them from the CalOSBA website, calosba.ca.gov, and you can click directly to the YouTube channel from the header, or click on Connect with CalOSBA, and you'll see there a page that's clearly labeled webinars. So you can find all of the series for up to date and moving forward. So Bianca, thank you again for your time, and I look forward to our next webinar together.
Absolutely. Thank you so much for having me.
Bye-bye.
Bye, everyone.